We also looked at the form of tender and schedule, and there are 13 changes. The same kind of strata of changes. Some are negligible, some don't make any difference whatsoever, but some of them are very substantial and will have immediate impact. The arbitration costs issue we've already dealt with. I think that's far and away the most outrageous change. The works requirements, we're now told that all of the works requirements are going to be clearly identified in clearly identified volumes or bundles, which will be listed in the tender and schedule. Again, that's a really positive change. You will know from the moment you receive the tender package exactly what the works requirements are, without anybody adding to them or taking away. It's all down to clarity. It's a positive change. The insurance changes are a positive change as well, as far as I can discern, subject to what brokers say, but they appear to be allowing you to insure against the risk, some of the risks you're being asked to assume. Weather events, substantial change there, and I'll come to that in a moment. Naming of specialists, again, a substantial change. And VAT, it appears to be the case that all prices submitted, the default position is that all prices submitted are to be exclusive of VAT. Okay? And I think this has arisen because there have been any number of challenges where contractors have submitted prices subject to VAT, exclusive of VAT, or ignoring VAT altogether. And this has resulted in challenges and confusion at a tender assessment stage. The default position appears to be that all prices submitted should be exclusive of VAT. However, you still have to check it very carefully with each tender that you're submitting, because there are options available to the employer to change that. There's a change in Schedule 1K. This is dealing with weather now. There's a change in Schedule 1K in the section that deals with ground conditions. And what they've done is they have inserted a provision which says that unforeseen ground conditions are a compensation event for which you may be entitled to money and should be entitled to time, depending on what boxes have been ticked in the schedule. But the change is that provided those unforeseen ground conditions don't result from weather, you will be entitled to time and you will be entitled to money. Now, again, my view on this is that somebody somewhere has got a massive claim in arising out of flooding or snow or ice, and has said that this weather event has caused a very substantial change in the ground conditions that I've been asked to deal with, and therefore I'm entitled to time and I'm entitled to money. So the purpose of this change is to exclude that possibility. So the risk of weather remains with the contractor. In terms of money, remains with the contractor. The other thing that has changed is that when we looked at version 1 of these contracts, we thought that the definition of weather event included such extreme conditions that it was highly unlikely that anybody would ever be entitled to claim for a weather event under these contracts. And the weather event provisions in version 1 they weren't difficult to understand, but the extremes and the circumstances in which you could claim for weather were actually going to be very difficult. I brought along a version of a document called WE1, because in Schedule 1K it now says that a weather event is not a weather event unless it is a weather event as defined in document WE1, which actually breaks down the different weather stations around the country and gives you minimum and maximum rainfall and minimum and maximum temperatures and wind rates for each of the weather stations around the country. It runs to 17 pages at the moment. So if you're going to claim for weather, the first thing you need to do is download this document and figure out whether or not you can actually claim for weather at all. The fact that they have introduced this new document means that it can constantly change and be constantly updated in respect of current events. I don't think they want to give you any time for weather at all, okay, under these provisions. The third very substantial change to the form of tender and schedule is the fact that now, in Part 2 of the schedule, there is a section which says, if the contracting authority says so, you must identify the specialist that you're going to use. Okay? So the contracting authority gets to fill out in the boxes in Part 2 of the schedule the particular elements of the works in respect of which he wants you to identify a specialist that you're going to use, and you must identify that specialist at tender stage. Okay? If that specialist is identified at tender stage, then you cannot change the specialist if you're awarded the contract. You must stick with that specialist as named. The invitation to tender is amended to take account of this new provision in the schedule. I think this is going to have a serious impact on the ability of named subcontractors and contractors to negotiate with each other and to actually do deals, because the obligation is to nominate yourselves. This is not a nomination in the old sense. This is a nomination. This is a specific requirement on the part of the contracting authority for the main contractor to name his groundworks guy, to name his electrical guy, to name his ventilation guy. This is a specific requirement where you will be asked at tender stage to identify the specialist you're going to appoint, and that will then undermine the ability of a contractor to go out, having won the contract, and negotiate with a number of different specialists to get the best deal. You have to do your negotiation before you get the contract. That's the bottom line. If the contracting authority names an element of the works which must be, where the specialist must be named,